Let's take a look at why adjudication is used in administrative law. Adjudication is used primarily for five overlapping reasons: agency convenience, advantages presented by incrementalism, suitability for resolving conduct and application cases, equity and compassion, and satisfaction of constitutional procedural due process. Despite its cost and difficulties, adjudication has several advantages for agencies. It generally affords them considerable flexibility in enforcing policy. This is especially true when agencies have the discretion to initiate cases and invest their enforcement resources whenever they deem them most appropriate. When agencies have broad discretion because there's no clear law to apply, they may find it easier to change policy by adjudicating than by rulemaking. Rulemaking and rule rescission are publicized through the Federal Register. They can prompt comments from any person, group, or entity that cares to offer them. Broad participation, coupled with requirements for cost benefit or various impact analysis, can make establishing a satisfactory rulemaking record difficult. Adjudication generally attracts less public attention. Participation can be restricted, and adjudication is subject to weaker legislative and executive oversight than rulemaking. Agency adjudicators are not required to consider the impact of their decisions on sets of specific policy concerns that are extraneous to other agencies' core mission, such as environmental justice, families, protecting small businesses, and federalism. Adjudication also affords agencies flexibility in that it is difficult to win legal challenges against incremental or even abrupt policy changes introduced in individual adjudicatory decisions. An agency can usually distinguish the basis of a new adjudicatory order from an earlier precedent in terms of the specific facts, changes in public policy or economic concerns, technological developments, and other considerations that a rational decision maker should take into account. Multi headed boards and commissions may especially prefer adjudication to rulemaking when they have highly fragmented policy preferences or are uncertain about the direction in which their agency should move. Adjudication provides board members and commissioners with a forum to resolve their policy differences and arise at compromises, often in an incremental fashion. Each can explain why he or she would decide the case in a certain way and what the policy and the other advantages would be. A board or commission that would become deadlocked in a rulemaking might nevertheless be able to carry out its functions through case by case adjudication. When an agency is charged with regulating and implementing law in a new or uncertain field of public policy, incrementalism may be advantageous. This is especially true when a legislative delegation is particularly vague or a technology is new and in flux. Broadly construed, conduct and application cases encompass a wide variety and range of administrative decisions. Adjudication is desirable in conduct and application cases because they turn on specific facts or individual motives. By allowing effective parties to present their claims and challenge those raised against them, adjudication guards against arbitrary government action. Adjudication may be particularly favored in cases involving individuals' eligibility for welfare and other safety net type government benefits because it has the capacity to promote equity and compassion. Equity and compassion may be important factors in promoting the policy objective of helping people who need welfare and safety net programs to deal effectively with their economic and other problems. In this context, equity entails the ability to make principled expectations to general regulations when they serve the interest of both the government and the individual.